Transferring ownership of corporate stock isn't as simple as handing over a piece of paper. Without proper documentation, shareholders risk legal disputes, tax penalties, and even invalidating the transfer entirely. A shareholder transfer agreement is a legal document that outlines the terms for transferring shares from one party to another. This comprehensive contract protects both buyers and sellers while ensuring compliance with corporate bylaws, securities laws, and tax regulations. These agreements are used in various scenarios, such as when a partner leaves a business, during inheritance planning, when startups bring in new investors, for employee stock buybacks, or in family business succession planning. A properly drafted shareholder transfer agreement contains several key elements. It specifies the buyer and seller, identifies the business whose shares are being transferred, details the number and type of shares, and states their agreed value. The agreement also covers payment terms, including deposit requirements, payment deadlines, and the closing date. The agreement typically includes representations and warranties from both parties, conditions that must be met before closing, any restrictions on future transfers, and provisions like right of first refusal that may give existing shareholders priority to purchase shares before outsiders. Shares generally come in two main forms: voting and non-voting. Voting shares give stockholders the ability to vote on corporate policies and board of director positions, while non-voting shares do not provide these privileges. Transferring shares involves more than just signing an agreement. The process often requires board approval, especially if mandated by the company's articles of incorporation. The corporate share register must be updated to reflect the new ownership. Original share certificates need to be endorsed by the seller and delivered to the buyer. Some jurisdictions require notification to regulatory authorities, and the transaction may trigger tax reporting obligations. As corporations present special considerations for share transfers, these entities offer liability protection while avoiding the double taxation of standard corporations, but come with significant restrictions. S corporations can have a maximum of 100 stockholders. Partnerships and outside corporations cannot own S corporation shares. Non-resident foreigners are prohibited from holding shares. Additionally, S corporations often impose stockholder agreements with rights of first refusal and designated share prices to preserve their tax benefits. Share transfers can trigger various tax consequences. Sellers may owe capital gains, tax on profits from the sale. Transfers below fair market value might incur gift taxes. S corporation transfers must comply with eligibility rules to maintain tax status. Some states also impose specific transfer taxes on stock sales. Private companies face unique challenges with share transfers. Unlike public companies, there is no established market for shares, making valuation more complex. Existing shareholder agreements may impose restrictions on transfers, and most importantly, transfers can significantly impact control dynamics, especially in small businesses, where each share represents a meaningful percentage of ownership. Before proceeding with any share transfer, review all governing documents, including shareholder agreements, articles of incorporation, and corporate bylaws. These often contain restrictions on who can buy shares, required approvals, or specific transfer processes. Given the legal complexities and potential pitfalls, seeking professional legal counsel when drafting or reviewing a shareholder transfer agreement is not just advisable, it's essential. An experienced attorney can ensure the agreement protects your interests while complying with all relevant laws and existing corporate documents.